What issues are the Supreme Court justices examining? Is it just one part of the federal health care reform law, or is it all of it?
Well, Monday's court announcement includes 4 legal questions to be presented. The dominant issue that's attracted the most attention, as you already mentioned, is the constitutionality of the minimum health insurance coverage provision, or so-called individual mandate requirement. They also will consider to what extent, if any, the mandate can be severed, that is, whether other parts of the law can go forward if the coverage requirement is found unconstitutional. Lower courts have differed on that question. They will also hear arguments on the constitutionality of the Act's Medicaid amendments. Florida's case argues that the law exceeds the, quote, enumerated powers, unquote, by creating such a major expansion of the Medicaid program. Finally, they'll hear arguments on whether the issue is so-called ripe or timely for a decision. Some lower court judges have pointed out that the penalty for not having insurance is the same as a tax and therefore cannot be challenged until taxpayers actually have to pay it in 2015.
Until a decision is made by the Supreme Court, will states have to comply with elements of the federal health care reform bill?
Well, it's widely accepted that states do need to meet the requirements of the existing federal law. However, most requirements actually are options for states with a federal fallback if a state chooses to stay out. For now, keeping up with federal deadlines are the main requirement. For example, states wanting to comment on rules detailing exchange operation needed to submit their comments by October 31st. Meanwhile, there are optional federal grants for many of the provisions to plan establishing insurance exchanges, planning Medicaid agency changes, and putting in place consumer protections. Virtually all states have applied for and accepted these federal funds to pay for implementing specific changes. Many state policymakers tell us they prefer that their state government create health policies and features rather than opting out and letting the federal government come in to do so for them. Finally, one of the biggest and mostly bipartisan state and local concerns remains this tight calendar. By June 2012, when the court may rule, only a dozen states will still be in session. This means that many legislators face key decisions in the next 6 months.